Hello and welcome to today's webinar, Consortium and Collaboration Agreements on behalf of Legal Futures. My name is Peta Dollar and I'm a freelance lecturer, trainer and writer. I have a great deal of experience when I was in practice, which I was for 25 years, a great deal of experience of both consortium and collaboration agreements, and I shall be talking about some of that experience during the webinar. So we're going to focus on two things today. First, consortium agreements, and what I mean by that is an agreement between two or more developers, especially house builders who tend to deal with consortiums a lot, who are developing a site together or sharing a site. And the second topic is collaboration agreements. And what I mean by that is an agreement between two or more landowners who own adjacent land and who essentially want to combine their land holdings so that they can be developed as a whole. And the idea is that they will basically enter into an agreement all at the same time with a single developer. Now, there are serious pitfalls involved in both consortium agreements and collaboration agreements, and that's what I'm going to focus on in this webinar. Particularly, there are some complex tax issues, and I would recommend that specialist advice be sought in every case. Obviously, I know that some of you have colleagues that you can turn to, specialist tax lawyers. If you don't have specialist tax lawyer colleagues, then obviously you can always go to a specialist tax barrister, or indeed encourage the client to seek advice from their accountant or other financial advisor. So I am going to be speaking about some of these tax pitfalls, but only in relatively general terms, and you really should be seeking specialist advice on this. So, what are we going to look at in the context of consortium agreements? Well, what type of structure is best in the particular circumstances of the case? Should the consortium members form a company or some other kind of artificial entity like an LLP or a limited partnership or whatever to carry out the development where the consortium members become shareholders in that company or owners of units in the entity? Or should they simply enter into a contractual arrangement amongst themselves with no separate entity being formed? And depending on what structure they choose, could it turn out to be a partnership that is being formed accidentally? Should the development site be held in joint names? If so, what are the issues that arise here? Should one member be appointed to carry out parts of the development or indeed the whole development on behalf of another party or other parties? What issues arise from agreements with the landowners? Assuming, obviously, that the consortium does not already own the land when the consortium agreement is entered into. What issues arise in relation to Section 106 planning obligations? How should costs be dealt with? How should disputes be dealt with between the members of the consortium? And as I've already said, I shall be mentioning some important tax issues to bear in mind. Turning then to collaboration agreements, we're going to be looking at the issues to be covered between the landowners at the outset. That's when they get together before a developer is found. We're going to look at the issues that will need to be covered between the landowners once a developer has been found. We're going to look at equalisation, which it has to be said is one of the most difficult areas of a collaboration agreement. There's the question of whether the landowners should enter into individual agreements with the developer or whether they should enter into one single joint agreement with the developer. And the big pitfalls, tax and also collective investment schemes. And I'm going to look at those pitfalls and what you need to keep an eye on there. So let's start with consortium agreements.